of trusts or trusts versus wills, please watch that first, because a lot of what I'm going to cover today is going to extend upon that. If you don't watch that, a lot of that may not make sense. So let's go ahead and get started. And what I want to explain before we get started is really the experience. So why I'm bringing this to you and where this actually comes from. So to give you a little bit of history, so when I started in working as a financial planner and working in designing estate plans for people, that included working with a lot of estate planning attorneys, elder law attorneys, litigation attorneys, estate litigation attorneys, and I was working with a large firm. And that went on for about 9 years. And what ended up happening was I left that firm to start my own firm to, put my own shingle out. And what I thought was going to be an honor was turned into something that was very different. Because when I left that firm, a lot of the clients went with me and they had asked me to be their trustee. Well, at the time, thinking, hey, not a big deal. This is kind of an honor when somebody asks you to be their trustee or their trust protector. And I said, okay, well, I'll take this on. And I did. And it was not only one of the greatest learning experiences, so I don't want you to misunderstand what I'm about to say, but it was an absolute circus. What I mean by that is I did that for about 11 years. I acted as a trustee for certain families. And during that 11 years, I had fistfights in my conference room between beneficiaries. I had scam artists, con people. Basically, when you're a trustee and you settle an estate and you go on to be a trustee, you find out things about human nature that maybe they don't teach you anywhere else. The minute you put a large lump sum of money on the table, things change. People change. And that became a very important lesson in how we do everything, how we design estate plans, how we talk to clients about what to be careful of within family and outside family. And obviously, I don't do it anymore. I will never do it again. Life is much happier when I'm not acting in that kind of capacity. But I will tell you that what I bring to this discussion today is not just the college type of education or the educational aspect. Like, you can go online anywhere you want and you can say, tell me about a revocable trust, or tell me what is a healthcare power of attorney. Now, I'm not here, I'm going to help you educate you on those things, but more importantly, what I'm going to do is I'm going to help you understand from many years of experience, it's not just as easy as just going and drafting a trust. It's what goes into the trust and how you design it. Now, look, the Titanic sunk and 1,100 people died. There were not enough lifeboats. So what a lot of people could step back and say is there were lifeboats. Well, it wasn't measured. It wasn't planned. They left the port with this idea that nothing can ever happen to this ship. And obviously, the engineer said it's a double hull. It could never sink. And they never planned that it could actually sink, because they never planned they could hit an iceberg. And so this is a lot like that scenario where with an iceberg, you only see just the tip. You don't see 80% of it under the water. So when you design an estate plan, this is about seeing what's under the water. And so hopefully today I'm going to add a little flavor, a little experience in actually settling estates and actually acting as a trustee so that you're better prepared in what you design. Now, this doesn't just mean that it's going to protect you while you're alive. This also means that it will hopefully keep family harmony as you go along. So let's get into the first part of Advanced Trusts Part 2. So the first question is, do you want a probate trust or just a bloodline trust? We're going to cover that. What type of protection do you want for your beneficiaries? How do you choose your beneficiaries correctly or your trustees correctly? And what other documents are going to tie into your trust, such as a pour-over will, advance directives, durable power of attorney, springing power of attorney, or healthcare power of attorney? And how do you go about correctly managing and updating your trust? So we're going to start off with what I call the most popular type of design. It is called the probate-only trust. It is the simplest trust that's out there. I probably see this 99.9% of the time. And if you asked me why I see this most of the time, I could probably come up with a couple conclusions. The first conclusion is it's software based. Now, I tell people that when they get an estate plan done, there are a few different ways that whoever is doing that estate plan for you can draft it. No individual practitioner is going to sit down and type out 140 pages. They're going to either use a template. Now, the risk of using a template is that they don't update the templates, and I've seen this quite a bit. People will come in and I'll know the exact legal firms or the law firms, or I'll know the legal document preparers, because when a client comes in and I'll see the name that it was prepared by, I'll know that they don't want to spend the money on the software. And they just take basically a Word document and they just fill in the names, and they don't change it based upon tax law, estate law, and the needed changes. So that's, I think, one of the worst ways that you can get a trust done. Number two is software. Well, software is a necessity. A lot of times people come in and go, I don't know why I paid $3,000. All the guy did was filled in the names. Well, let me explain why. The software is very expensive because it has to include every tax change, legal change, and it is quite extensive. I mean, if you just look at the IRS alone changes the IRS tax code over 400 times a year. There's 400 changes per year, and a lot of that has to be included in your trust change. So software is an absolute given. Now, why do 99% of them look like this, what I'm about to show you? It's pretty simple. There's three main software vendors that are out there that will sell a software program to either a legal firm or a legal doc prep firm. Now, you have to have a license to get this software. It's not something you can go to Office Depot, or you can buy online your $49.99 will and trust kit. And boy, don't I wish it was only that much money. Yeah, it's a lot of money for these programs in the tens of thousands of dollars, but the key is you got to have a license to get it. Now, there's only three major vendors that are out there. Unfortunately, almost every vendor out there has the same exact templated language, which is the probate trust. Now, most people that produce trusts, they're just going to fill in the names. Now, it's still a justified cost. I mean, even if you go to somebody and they use one of these high-end softwares, and they have a license and they have E&O insurance or malpractice insurance, look, you're not just paying somebody to fill in the name. There's a lot of costs that go into getting you a good product. But the problem is that many of these practitioners that fill out the forms, or they have their paralegals fill out the forms, they're just filling out the software as it comes off the shelf. And the problem with that, well, I'll go through that problem and I'll tell you about somebody that I know that this happened to, but I want to show you the probate only trust first. I just want you to understand that 99% of every trust out there has or is what I'm about to show you. So let me go through the example and then I'll fill in a story so you can understand how this works. So again, 99% of the programs that are out there is going to produce this, what I'm about to show you, this language, and there's probably a 9 out of 10 chance that if you already have a trust, you probably have this kind of trust, and it's called a probate-only trust. Now, in the middle box, you'll see last to die, and we're just going to make an assumption here that there are 3 children, and we're going to assume that you did your job, or whoever you hired did their job, and you drafted your trust, and you funded your trust. And when I say funded your trust, what I mean by that is you've added all of your assets. You've retitled your house. You've changed all the beneficiaries on your annuities, your life insurance, your retirement plans. You've retitled every brokerage account statement, every bank account statement. So we're going to make the presumption here that everything has been done right at the trust level. Now, if you remember in the trust part 1, I said that 50% of getting a good estate plan to not lose money is funding your trust, but I also said the other 50% is in the design and drafting of your trust. And that's really what I'm going to talk about here. You're going to see a design. So we're going to use the assumption that this first child is married. And we're also going to use the assumption that that first child is the only child that you have grandchildren with, and that child has 2 grandchildren. And as you can see, child number 2 is single, and child number 3 is married but no children. So I'm going to show you how this mistake happens. Now, before I get into the actual design of this, I want you to understand that most people will come to us, we'll show them this, and they'll say, well, no, that's not me. My trust says if I die, or when I die, not if, but when I die, if my child, we'll use child number 1, is not alive, well, actually, let me use child number 3 is not alive, then his share of my assets will be divided between child number 1 and child number 2. So if child number 3 here dies, the presumption is that child number 1 and child number 2 will get the money. Here's the problem. People don't understand that language. And what happens is if child number 1 predeceases you, yes, that would be the case. But statistically, the chance of a child predeceasing you is less than 1%. So statistically, there's a 99% chance you will die first. Now, if this child over here, child number 3, gets the assets and then dies in a probate-only trust, it's not going to pour over to the other children. Let me show you what happens. We're going to use a term that I coined many years ago called the 3DL risk. And that stands for death, disability, divorce, and lawsuit. I'm going to cover each one of these. So first, if I pass away, or if you pass away, whoever we're using this example of, if you've made the presumption that you're going to give 1/3, 1/3, 1/3, then that 1/3 is going to pass out to each of the beneficiaries. So it's important to understand that after these assets pass to the children under the probate-only type of trust, that trust is going to go away. It's not going to have any use, any purpose. It's done its job, right? It's going to go away. And what will happen is the trust literally will be shredded because the children got the money. There's no purpose for the trust anymore. Now let's go ahead and go on to the next step. And what I'm going to do is kind of give you what I call the week of disaster. So let's say that on Monday, mom and dad die. And again, it's the last to die. If it's single person or divorced person, the other person is passed away already. It's when that last person in the trust dies. So they die on Monday. On Tuesday, let's go back here. On Tuesday, child number 1 gets the money. So you have to ask yourself the question, who has the legal title to that money at that point? The child has the legal title. So your trust does not operate anymore. It's not controlling anything. It's not protecting anything because what did it do? It passed the assets down to the child, right? So now let's say on Wednesday, child 1 dies. Here's the question. Where does that money go to? That's right. Well, let's say on Thursday, it's going to go to the spouse, right? So let's say on Thursday, the spouse is now done grieving. Now, it was a short grieving period, right? And on Thursday, the spouse is going to get remarried. And now let's say that on Friday, that spouse dies. Or let's say that that spouse gets divorced. What ends up happening? The grandchildren are cut out of any kind of inheritance at all. Now, this doesn't happen with just death. This can happen because of a lawsuit. Why? Well, if the money is technically in the child's name, let's say child number 2 here, and let's say that they're driving through an intersection and now the sun's in their eyes and they think it's a green light, it's a red light, and they take out a neurosurgeon at an intersection making $2 million a year. Well, unfortunately, that child's, little $250,000 or $500,000 liability coverage on their auto insurance is not going to cover a $10 million claim. Remember, because if they kill somebody that's making $2 million a year, there's going to be a pretty large claim. So again, because the money is in the child's name, we passed over what we call the ownership barrier, then they're going to lose that money. Well, let's go over here to a divorce. Let's say that the child over here, child number 3, is married, You pass away, you leave the money to child number 3, and they get a divorce. Well, there's this old wives' tale, and I know it's still prevalent, that people believe that, well, as long as the child keeps the money in their own name and they never combine that money, there's no way that that divorced child or the divorced in-law is ever going to get any money. That is not accurate at all. I can probably sit here for hours and tell you case after case after case. I'll tell you one very good example of this case. So while we were in Los Angeles, we had a person come in, and this person had just gone through such a divorce, and they asked us if we could look at the financials and see if we could help them out. And here's the premise of this case. This person was inherited a very large apartment building in West Hollywood. And this person inherited that from their parents, and their parents instructed this person, keep it separate. Don't put it into community property. Make sure it stays separate. Keep a separate checking account. Keep everything separate. And this person did for almost 10 years. Well, when this person got divorced, the wife's attorney, well, to give you some background, this person was on TV and they had a TV contract, and you know, there's no guarantee with those things. They can cancel a season anytime that you turn around. And so the wife's attorney basically pled the case. And how do I know this? He brought me all the pleadings, but I read this, and the attorney, the wife's attorney, was very good. What he said was, look, this person has no guarantee in income. They could get a show canceled and never get another show. And the apartment building is providing over $1 million a year in net income, and that's the guarantee. And so while the joint total income was a lot more, they were successful in winning the case that the income from the rental property would be assigned to the wife as alimony. And he could keep whatever he makes on TV. Now, of course, he didn't like that, and he still wasn't getting it. And he said, well, how can they go after that money? I said, well, it's really simple. I said, even though you kept the property separate and you kept the checking account separate, that's great. But what happens is because you brought that money into your marital property or operation and you spent that money, and the family enjoyed that money during the time of your marriage, and she had a really good attorney. And this is what happens, because I tell people, listen, don't just take what you hear on the street, because what I've learned is just seeing all these people that come in and these things have happened to them, is it's pretty much based upon whoever has the best argument in that court case. So again, divorce is one of them. Disability is yet another one. I'll give you another example of this. So this is in our Florida office, and this goes back many years ago, but the client came in to hire us to do a financial plan, paid us a check to do the financial plan, and went away, and we had completed the financial plan, and we called him up, no answer, emailed, no answer, sent somebody to his house, no answer. A few weeks later, the son came to our office and said, well, you know, my dad had passed away right after he had written you a check. And I said, well, my gosh. I said, that's terrible. Let me refund you the check. And he said, no, you better keep it. He says, I think I'm going to need your financial expertise, because let me show you this. And so he showed me a letter from the IRS asking for close to $500,000. Let me explain what happened. So the father was a Florida resident, but the son was a resident in Pennsylvania. And in Pennsylvania, they have what's called recapture rules. That means if you take Medicaid from the state, or SSDI, which is Social Security Disability Income, then if you come into some money, they can take it back. So as soon as the father had passed away, because the father named the child as the beneficiary, and again, we hadn't finished a plan for him yet, so our plan wasn't in place. This is how he had it prior, but I find most people make the fundamental mistake of naming a human as a beneficiary, whether it's a spouse or whether it's a child. So in this case, the father had named the son as the beneficiary. Father dies. There was over $890,000 sitting in his IRA. The state of Pennsylvania went right in there and took it all out. Well, that's bad enough. But to make matters worse, because the son was the legal beneficiary, the IRS said, well, you took an IRA distribution because he's the one that got the 1099. And so the unfortunate thing is that The son has this IRS liability. So again, you have to be very careful as to not only how you name your beneficiaries, but crossing over what I call that ownership wall or that ownership line. Okay. So what does the probate trust really do? There's only two things that it does. The first thing that it does is it eliminates probate. The second thing that it does, it is assigns financial responsibility if you are disabled. So let me make something clear with a probate only trust. It does not do two things. It does do two things, which is probate and the financial responsibility, but it does not have asset protection for you while you're alive. And it also does not have any type of asset protection for your heirs, your beneficiaries, or your children. Now, with that in mind, I'll tell you a quick story about somebody that was very close to me. This person had developed a very high net worth. And if you looked at that net worth today in the year 2020, that net worth would probably be somewhere in the area of about $50 million. But this happened many years ago. And this person was a very smart business person. He had real estate. He had all kinds of assets. And this experience that I'm about to tell you actually happened to me when I was very young. I saw this happen when I was about, I think, 12 or 13 years old. And so anyway, this person had developed a very, very large estate back then. And he had passed away. And he had left his estate to his wife. Unfortunately, the lawyer that had drafted his estate plan was not an estate planning lawyer. And I'll comment on that in that, unfortunately, in the legal profession, there is no bar that you have to pass. There's no criteria that a lawyer has to have to draft a trust or draft a will. It's just kind of an add-on service that they can provide. And this attorney that was representing this person that I'm speaking of, he was his real estate attorney. So because they had a close relationship and because there's this misunderstanding about a lawyer who can draft the trust, this person just took the presumption that, oh, he's a lawyer. He's got to know what he's doing when it comes to trusts. Look, there are specializations within everything, and there are lawyers that specialize in estate planning and in elder law. But I can tell you that just because you ask a lawyer, do you know how to do a trust? Yes, I know how to do a trust. Well, that means he knows how to plug in the software. Doesn't mean that he's got 20, 30 years. It doesn't mean he has acted in the form of a trustee. Doesn't mean that he's settled estates. It also doesn't mean that even if they have, it doesn't mean that they're not running a profitable business. And what I mean by that is I've seen very prominent lawyers who really do know their stuff, but they don't take the time to sit down and really customize and custom design a trust because it's not as profitable as charging a couple grand, plugging the names in, or actually having their paralegals plug the names in, kicking it out. So when it comes to lawyers, you have to make sure that A, the lawyer is an expert in that area, and B, they're actually going to take the time to design it. And three, maybe you've got to make sure that they've had the experience, because I've actually had people come to me and say, well, this lawyer, he teaches this in college classes. Well, what I'm about to show you here, they don't teach in college class. You can teach in college class the laws, the proper way to draft the trust by statute, but you can't teach what really happens after you draft a provision. So to go back and going back to the lawyers, again, this is why in the legal profession, once you pass the bar, you can practice any kind of law that you want. I'm going to compare that to, say, a physician, where a doctor, let's say he gets his MD, but he wants to be an orthopedic surgeon. He's got 6 to 8 years where he's got to study to be in that specific area. So all I'm saying is that just because a lawyer drafted that trust does not mean that this is going to be a great design. You just got to make sure you know who the lawyer is, what their background is, what their experience is, what their care level is, etc. So going back to this person I was explaining before. So this person had this lawyer that, again, was not an estate planning lawyer by any means, draft his trust, and then all of a sudden he passes away. And this trust that this real estate lawyer drafted was not very strong. And what it did was it passed everything directly to the wife, but it didn't have any strength in protecting it onto the children. So it was about 15 months later, the wife remarried, or no, it was actually about a year later, the wife remarried. And then about 15 months, then she passed away. Well, unfortunately, everything in the trust wasn't secure, so it all went to the new husband, just like I explained right here. And I will tell you that because 9 out of 10 people are walking around with this kind of trust, this happens a lot more than you can imagine. We see this, I would probably tell you, 1 to 2 times a month. Somebody will call one of our financial planners and they'll say, my mom died and everything went to another family. My dad died and everything went to another family. What can we do about it now? And generally, unless you want to sue, and that's a lot of cost, a lot of expense, a lot of emotion, generally there's nothing that you can do. And I can't tell you, you'd have to contact a lawyer to figure out what your options are. But I'm just saying that it's a horrible situation just to see, because somebody's using a piece of software, because they're just plugging the name in, and they're just, people make this mental relief. Oh, I got my trust. Most people don't even know what's in their trust. They just say, oh, I got my trust. They go home and the husband and wife look at each other and go, whew, we got that out of the way. Let's put that up on the shelf. And okay, what's next, honey? Hey, don't we got to call and find a new landscaper? It's like a task to them, and they don't really understand what they have. It's just like they just completed the task. Let me show you a different design. Now, this design is going to really help you understand what your options are. Now, I explained a probate-only trust to you. Now, let's go through what is a bloodline trust. Okay, a bloodline trust, we're going to use the same situation, child 1, 2, and 3, same grandchildren, same spouse. And now what we're going to do is we're going to change some of the language and how the actual trust is designed. So the money is going to still be in the trust, just like we did before. It's the same process of getting that money funded into the trust. But now we're going to create a protective wall. And the reason that we're going to do that is it's going to create asset protection. You remember in the prior example, I said that when the person dies, the money leaves the trust and just changes ownership to the child's name. Just like that apartment building in West Hollywood. Mom and dad said, here you go, it's yours, it's in your name. And while he only kept it in his name and didn't put it into community property, you saw what ended up happening there is the wife got all the rental income. By the way, you want to talk about something that's got to be disheartening. You have this, $10 million rental building. You have to manage it, and it's producing $1 million a year, and you got to hand it all over to your ex-spouse. And now people will say, yeah, but he still has the asset. Great. He has to manage an asset that he gets no economic benefit out of. Anyway, I digress. Anyway, going back to the bloodline trust. So you've got this protective wall, and it's going to provide asset protection. Now, this is not asset protection to the people that fund the trust, to the grantors, the people that create it. It's going to provide asset protection to the children and or grandchildren. So here's how it's going to work. Instead of the children actually getting dollars, instead of the trust going, here's whatever it is, if it's $1 million, $333,000. Instead, they're going to get what's called a beneficial interest to a trust share. Now, remember before, the trust went away. After the money was distributed, it was gone. It was disseminated, right? So now what happens is that trust share is going to be kept, that money is going to be kept in the trust, but each child is issued a trust share. Now, when you design your trust, can you design different trust share percentages? Of course, I'm just showing you 1/3, 1/3, 1/3. Now, what would happen as an example if child number 2, let's say, has a disability? And we'll use that example of that person from Pennsylvania. Well, actually, what you have to do is put what's called a special needs provision right here in this trust share that says don't distribute out anything to this special needs child because they might be on SSDI or Medicare, because we know that if you distribute it out, it's just all going to go away. And what good would that do? So what we're going to do is we're going to allow the trustee to only distribute income and assets to that child that does not eliminate them from whatever kind of government benefit, and does not subject that trust share to confiscation by the government. So when you issue those trust shares, each child has the ability from that trust share to get income. So this child might decide to get more income than this child. This child might decide to get more income than this. This is the beauty of this customization that you can do with a bloodline trust. So a lot of times people will come to me and say, yeah, but I just want to give them the money. Listen, if there's one thing in this country you want to be aware of, is that it is never a good idea to own anything. You want to control it, but don't own it. Why? If you own it, it can be stolen. It can be taken away from by the IRS. Somebody can sue you. Somebody can divorce you. So again, control and the economic benefit of something is much better the control is much better than ownership. So look, would you care if somebody said, I'm going to give you the use of this automobile for the rest of your life? You have to maintain it. You have to pay for the insurance on it. But you can drive it anywhere you want. The ownership just stays in the trust. On the flip side, let's say that somebody said, here's a house. And you can do whatever you want with the house. You can paint it. You can change the walls. You can do whatever you want with it as if you owned it, but you don't technically own it. It's not technically in your name. I don't know about you. I don't really care. What I care about is, can I use the house? And if I don't like that ugly orange on the wall, can I change it? All right. I have all the benefits of ownership without the downside of the ownership. So sometimes people say, but I just want the child to get the money. No, you don't. You want the money to be up here in the trust, stay up in the trust and stay protected. If that child can say, hey, I want to buy a vacation house, that's out of their 1/3 share. It's not co-owned by, because we use what's called separation of share ownership and confidentiality. This person doesn't even know that they have that house. This person doesn't even know that child one bought a vacation house. That child can educate children. They can use it for healthcare expense. The concept is you keep the assets within the trust because now the trust can continue to control, protect, and design and pour over assets to the other children in case something happens. It eliminates that ownership jumping the protective wall. So let's use an example. Let's say that as an example, in this situation, let's say child 1 passes away or child 2 passes away. What happens to child number 2's share? Well, if you're in a probate only, it's probably going to go to probate. Some people say, well, child number 2 can set up his own trust. Do you know how many times that happens? Come on now. I mean, we tell our kids to do stuff all the time. Does it mean that they're going to do it? Does it mean that they're responsible? Does it mean that child number 2 doesn't eventually get married and then whatever? Even if they have a trust, it's still not protected. Even if we leave them that money and they get sued, it's not protected. So it's a great idea to say, well, child number 2 is going to be a responsible person. Even if they are, it still doesn't give them the asset protection. So let's assume in this example, child number 2 passes away. What ends up happening? Well, in the probate trust, the probate-only trust, the money is going to go to probate and a judge will decide who gets it. But in a bloodline trust, the language says if child number 2 passes away, take that share, right? Because the money's not in that child's name, it's just a share. Take that share, and what I want you to do is give half of that share to child 1, give the other half of that share to child number 3. So if this child had $1 million and there was $1 million here, now that child has $1.5 million. If that child was taking a 6% distribution or $60,000 a year, now they're taking $90,000 a year, right? If that child, wanted to buy a $500,000 vacation house with that money, there it is. They can do that. It's in the trust, so the child never has physical ownership of it, so it stays up here in the trust. Okay, so let's go ahead and we'll bring child number 2 back. We're going to get rid of that example. And now we're going to go into the example that we gave you before within the probate trust. Well, now what happens if child number 1 passes away? Well, child number 1, remember, spouse got remarried, right? But remember, child number 1 does not own the money. You remember in the probate example, When child number one passes away, where did it go? It went to the spouse. But in this example, when child number one passes away and the spouse remarries, there's a wall. Now, you can make a provision that says if your grandchildren are minors, the income from the trust share can jump this protective wall to the spouse so she has money to bring up those grandchildren. But what we like is that if by the time that child is 18, and here's where I'm going to lend in, 3 decades of experience as settling estates and working as a trustee and dealing through these issues and working with 18-year-old and 21-year-old kids, I'm going to call them, because most of the time they do not have, I'd say 98% of the time, they do not have the wherewithal, the financial maturity, the understanding, nor what they really miss is the respect as to what it took to earn that money that they have been graciously granted to. And so what we like to do is put in a provision that says that upon, so if the child one dies, and these two children are minors, and whether or not that spouse remarries is going to be irrelevant, because there's going to be this wall in here that does not allow that spouse to inherit the physical income. They have the use of that income until the children are 18, but then there's a trigger, and it says, okay, that upon those children turning age 18, they have to make within 1 year of turning 18. So some kids, obviously, they have started school late, so they don't graduate from high school until 19 years old. But it says that either turning 18 or 1 year from them, they're going to have to give a written decision to this trustee up here as to what their decision is going to be as to what I'm going to show you next, which is one of 4 different outcomes, 4 different decisions. So what ends up happening is you can say, hey, while this child is alive, this child gets that trust income. They can buy properties and pay for health care. They can take money out of it to pay for the grandkids. But if that child passes away, there's a wall that's created. The income can go to the spouse while the spouse has these minor children. But the intention is that you're trying to stay within your bloodline. The minute you cross this wall, you get outside your bloodline, like in the probate trust. Like in the example I gave you, the guy that left it to his wife. The wife remarried, the wife died, and everything went to the other family. In this case, what's going to happen is that interest of that trust share is going to pass to the grandchildren. Now, that means that new spouse will never be entitled to any of that money from your trust. That's how you protect that. That's also how you protect the children from a lawsuit. Why? Now, if this child number 2 is driving through that intersection and the sun's in their eyes and they take out that neurosurgeon, that trustee is permitted to shut off trust share income. What does that do? Well, here's what happens. If there's a plaintiff's attorney and he says, well, we're going to attach to that trust share, and there's the ability for the trustee to shut off that income, it's going to be very hard for them to attach to something that they don't have physical control over. Same thing with a divorce. If child number 3 is married and they get a divorce, and in the provision of that trust, it can say that if this child is under attack, they don't have to provide any of the income from it. It shuts off the ability for this outside attack to go after that money. Disability is same thing. If there's a special needs trust or special needs provision. So as you can see, what this wall does is it provides that asset protection. Now, going back to the grandchildren, here's where we want to get into incentive clauses. Now, in incentive clauses, we're going to talk about incentive clauses and why I feel they're so important. And again, what I'm going to bring to the table right now is this 3+ decades of seeing what happens when someone does not have the proper management skills, the proper understanding, and mainly the proper respect of what it took you to earn that money. I tell people, listen, if you don't structure this right, or if you don't have the right plan, You're going to be flying coach, and your kids or grandkids are going to be flying first class, and they may run out of money. I mean, let's look at really why this is so important. We can look at the lottery winners and what happens with lottery winners. It's something, the statistics are something like 3 out of 4 people within 36 months lose all the money that they won from a lottery. And there's studies that show that the psychological disorder that they take on from winning this large amount of money, because of the stress, they don't know how to handle it. People are attacking them for money, and there's just all these new decisions. And so I tell you this because and the increase they show statistically when people win the lotteries, there's a substantial increase in drug and alcohol abuse, because this is the way that they soothe all this stress. So the reason I'm telling you this is that this is not coming from somebody that's just saying, hey, I know how to draft a trust. This is coming from somebody, this is my premise is 3+ decades of watching what happens when people make mistakes, such as they tell us, well, my kids would never do that. My kids always get along. They would always work cooperatively together. Yeah, okay. Listen, I've seen the proof that doesn't really happen. That's like putting one toy in a sandbox and then asking the kids all to share. And I've also heard people say, well, my grandchild is great, or I'm not going to worry about this because I'm going to be in the grave. And, if my grandchild needs to learn how to handle money, they'll learn it. No, listen, this is literally like handing a toddler a loaded gun. This is not what I see. I don't see kids or grandkids just picking it up and learning this stuff. I see human destruction by leaving this kind of money. Not only does it take the incentive away from that child, but it actually physically causes destruction. So when I try to explain the importance of incentive clauses, I know I get through to some people, but some people they can't because they haven't had the experience. I've had the experience where, a 19-year-old, when I was acting as a trustee, a 19-year-old kid, called me up and was yelling and screaming at me because he couldn't get a certain amount of money out. And so when I finally dug down a little bit deeper and I asked, well, what is the money for? And he said, well, I want to buy a car. And now we're talking about $300,000 this kid wanted to take out. And this kid never held a job, is 19 years old, and the grandfather drafted the trust, again, with these provisions in there. But the kid got really upset. And I said, well, look, there's nowhere in this trust that says that your grandfather intended you to drive a Bentley. And this kid was incensed. He felt entitled, that he deserved it, and he hadn't worked for a dime of that money. But see, this is what this kind of situation creates without incentive clauses. So over the years, what I'm about to show you is what I've created. I've created this, not that I can tell you that I've thought of everything or I've seen everything, because I haven't, but I can tell you that over 30 years, what I've done is seen where beneficiaries try to penetrate the trust. I've seen where they try to manipulate it. I had one beneficiary that I was a trustee of. This guy was in his 40s, literally in his 40s, never held a single job. And every year I had to write a check to this guy because his grandfather said in the trust, as long as he is in college, the trust is to pay for all expenses, living expenses, So there was this, $40,000 check a year. I don't remember, it's like 20 years ago. But I had to write him a large check every year. And all he did was he went to college, he matriculated, and then he dropped out. And then he would flip between different colleges. He met the requirements of the trust. So I see this kind of manipulation going on, and because people are going to try, it's human nature. This is what we do. The reason that we have automobiles and computer chips is that 100 years ago, people said, hey, why should it take 5 months to travel by wagon train from the Midwest to the West Coast? And then they came up with a train, and then they came up with automobiles. Now you jump on a plane, it's an hour, right? I mean, this is what we do. We try to figure out easier ways to live, and it's no different. You hand a person the ability to manipulate something, and you can destroy them. And this is why I feel that, this is me, just from what I've seen, I feel that if you're going to leave money to somebody, give them a carrot to chase after. Give them something to achieve so that there is respect to what you have left to them. right? Give them even a monetary incentive to chase, but it also protects them. Now, most trusts I've seen, I'll tell you another example. When I was living in Florida, a guy I played hockey with came to me and said, "Listen, I really would like you to, handle my wife's trust." And the grandfathers, just to kind of give you an idea that just because you think you have something in your trust that gives this incentive clauses, it doesn't all the time. And so I said, "Well, what's going on?" He says, "Well, my wife's grandfather left him a very large sum of, or her a very large sum of money. And at 25, she blew the first 1/3 of it. And at 30, because sometimes you'll see this, leave 1/3 at 25, 1/3 at 30, etc. And people think that this is the way that you do it. Remember, the problem with that is you cross the ownership barrier. Again, you're giving the lump sum out, and then that person still hasn't earned anything or achieved anything. So just because they're 25 or 30 years old does not mean that they have financial maturity. Look I have had people in my office with extremely high degrees. These people have been engineers, they've been architects, they've been physicians, they've been in their 50s and 60s. And just because it's an age does not mean that they have passed the mental hurdle of being a good steward of their money, that they know how to handle their money, or that they're going to make smart money decisions, right? So the goal of the tool is to finish the job, like a circular saw, right? You buy a circular saw to cut a piece of wood. That's the intent. Well, you don't want to cut off a finger and cut off an arm while you're trying to cut the piece of wood. So you've got to have some protection in these things. So the incentive clauses that I have created are as follows. This shows you how passionate I get about this. Let me go back to this guy. So this grandfather left the granddaughter this 1/3, 1/3, 1/3. So the guy comes to me and says, "Can you handle and can you protect her against this because she's blown the first 2/3?" I said, "I'll do the best I can." So they assigned me over and I started managing the accounts, and here you go. By the time she's 35, she gets her third. I'm trying to counsel with her. I'm trying to instill good money management. She never earned the money. She never understood it. She never respected it, right? So I'm doling out these little percentages to her on a monthly basis and hoping that she's going to better manage this. Sure enough, by age 35, she had run up so much debt that by the time that she got the final distribution, she had nothing left over. So again, just because you put these 3 little ladders in there, that's just a time period when somebody's going to get something. It's not an incentive. It doesn't make that person do something to acquire that money. So now, while these incentive clauses are not going to protect everybody, these are just what I've come up with over the years. So number 1, college, but there's going to be some bars. So in the language that I created, it says that they have to have a GPA of 2.75 or whatever you decide. It was funny because as my kids were growing up, I was threatening them. I said, I'm going to put 3.75 in there. So if I pass away, you're not getting anything unless you get 3.75. And later on, I told them a little secret. It wasn't 3.75. I just wanted to make sure that they understood that there was a bar to achieve. And what it goes on to say is that, look, if the child is having a tough time in college, then the trustee can pay for the tutoring. They can help them improve. But if they miss 2 semesters, then the income stops. Now, we created an incentive provision that does say that they can restart this at any time if, let's say that at age 18, they decide that they want to just drive across the country and they have this, recognition that in 10 years from now, boy, look at all that money sitting in the trust. I could have had some income from this. Well, you can't just decide at a certain age you're going to get something. So what it says is that you've got to pass one of these bars. 1 is you got to have college. 2 is you can join the military, but you got to be in for 4 years. You got to get an honorable discharge. But if you're married, we added this provision years later because we were finding that the military, if you're married and you're living on base, you're literally living in a terrible situation, especially if you have children. And sometimes the military families are actually on food stamps because they can't afford to buy the kids food. So if you're in the military, there will be a housing stipend if married. And the third thing is that they start a business. Now let me go back. So what happens is if you're in the military, and I should have explained this, is so you're in college, the trustee is going to pay for the college while they're in college, right? if they graduate within the time period allotted for the degree. So here's the other thing that we learned the other things that we include in this language. One is it says you can only change majors twice. Why? Well, 30 years ago, I started creating this incentive language. And so what I had kids doing is just jumping majors, and they were avoiding the language because they read the trust. These kids are smart. And they're going to go, as long as I just keep a 2.75, but I just keep jumping majors, I never have to graduate from college. And then here you go. You get a 40, 50-year-old college student that's never really contributed to society or really understood the respect that's needed for the money. The other thing that happens is if they don't graduate within this prescribed period of time for that degree, then they're out. So here's an example, a 4-year undergraduate, maybe a 5-year pharmaceutical, whatever that degree might entail. I think, what is a veterinarian, something like 6 or 7 years. Whatever the prescribed period of time is, they have to graduate within that time. Now, here's the incentive. As soon as they graduate, they're going to get an income from the trust. And typically what I find is most people will put that income at somewhere between 5 to 6%. So here's an incentive. We're just going to use a simple example. Let's go back to here. So now this child has a trust share of $1 million. They go through college, they meet the requirements, and let's say that the grandparents had set a 6% trust share. So now that child is maybe 23 or 24 years old. They've accomplished the goal. Now they would get 5 to 6% of that of the trust share per year. They'd get an income of $50,000 to $60,000, or they could do the same thing that their parents did. They could buy a house within the trust. If they get sued, it's protected. If they get divorced, it's protected. But they have to meet one of these incentive clauses in order to get that trust share income. So let's go back to where we are. So they're in college, right? They've met their 2.75. They haven't changed majors more than twice. They've graduated within the prescribed number of years for that degree. They graduate. Wonderful. They start to enjoy the income from the trust. Number 2, they're in the military. They're in for at least 4 years. They get an honorable discharge. If they are at the end of that deployment or that military service, then they enjoy the income from the trust. Number 3, well, maybe they're not, college material. Maybe they're like Steve Jobs or Bill Gates or Harrison Ford or on and on. There's, hundreds of people that are super successful people that just never fit into standard academia. And maybe they want to start a business. Well, now if they start a business, they can go to the trustee. They can ask for a loan, but they must submit a written business plan that conforms to the SBA. And they will loan the money. The trust will loan the money with the same rate as the SBA, Small Business Administration, but the money that they pay back all goes back into the trust, so it goes back into their share. After 4 years of on-time payments, then the trust can either A, pay off the loan, or they can start paying the loan, and if there's excess, then that child will get that money. Now, why did I add that provision? Well, years ago, 20-some years ago, I had this child come to me, or 20-something beneficiary, and said, Ken, I want you to give me some money from the trust so that I can start a business. And of course, I wasn't just the patsy who would say, well, here's a check. I'd say, I asked him, what is the business? Well, it's a distribution business. And all of a sudden I started getting really little suspicious, thinking, distribution? Huh? That's like the import-export for drug dealers. And I said, well, what kind of distribution business? Well, we're distributing, food. Okay, what kind of food? Well, ice cream. Okay, what kind of ice cream? Well, it's going to be an ice cream truck. I said, okay, not that I'm against that. It could be a good business plan. I said, so what do you want to do? He says, well, it's a $300,000 investment. I said, is it a franchise? I said, that's a lot of money for an ice cream truck. That was 20 years ago. He said, no, this guy's got this great deal, and he's going to make a ton of money I'll make a ton of money if I buy this. I said, do you have a business plan? No. I said, well, how do you know you're going to make a lot of money? Well, this guy said he's making this much money. I said, have you seen his books and records? No. Well, look, this is business, math, respect of money. I said, show me a business plan. He goes, I don't have one. I said, well, I can't give you the money from the trust to even start a business unless you show me a business plan. So I thought at that point, it's a pretty good idea. Put that in there as an incentive. Great. We want you to start a business. We want you to be an entrepreneur. We want you to be the next Bill Gates. But start by operating the way that most businesses don't. Get a written business plan that conforms to the SBA. Present it to the trustee. They'll loan you the money, the same as the SBA. After 4 years of on-time payments, the trustee can decide based upon the interest rate on the loan versus what they're making. Should they pay off the loan or should they just pick up the loan payments and pay them for you? If there's excess over what that trust share is, so if there's $1 million and the trust share says give you 6% per year or $60,000 a year, and the payments are $30,000 a year, well then the beneficiary gets the other $30,000 a year. That's the beauty of it, and then it's still asset protected. And go back to the flaws in the probate-only trust. If the parents had left $300,000 to that child buys that ridiculous investment, they're going to lose all the money. Or let's say the child actually had a business plan. They leave them the money, but then there's something happens with the truck. The ice cream truck runs over a kid and gets sued. Well, then all the money goes up in smoke. So it could even be a really good business plan, but it again emphasizes the need for that asset protection wall and keeping that asset behind that wall and only providing the income. Well, what happens if they do nothing? Well, I always said this is kind of like the get nothing, Harley or Harvard. So what it says is, you don't want to do anything, we're not going to just go ahead and just create a trust fund baby here. The Harley or Harvard thing that I brought up years ago was, when grandparents, I saw this when grandparents leave this large lump sum of money, and I've had kids just go buy a Harley and never see him again. They just travel across the country. Why? Well, they have a free ATM card. Some of them say, I'm going to do a smart thing. And not that I'm saying that college is the best thing or the only thing. I'm just saying it's what are they going to do? So I feel very strongly because of the experiences that I've had in seeing the human, emotional, and financial destruction of not leaving money the right way to the kids or the grandkids, and instilling a great tool with that money, which is create the hurdle, create the incentive. Look, we humans, you've probably heard that study about the eggs where scientists thought that what they could do is they could increase the production of hatching chickens. So they created a machine that would hatch the chickens. Well, when the chickens would hatch on their own, there was, and I don't remember the percentages, so I'm going to make them up, but it'll give you some idea. But it was a 9 to 10 ratio. So 10% of the chickens that would struggle to get out of the eggshell themselves would survive, 9 out of 10. However, what they found was that when they created this machine to break the chickens out of the egg on their own, only half of the chickens lived. So when we create an estate plan or a trust, and we do it just because it's on paper and because somebody said, well, now you have an estate plan and it eliminates probate. There's more to it than that. We have to design and think through, who am I giving the money to? When am I giving the money to them? How am I giving the money to them? Can this actually create more financial destruction and emotional destruction than them not having the money? We've seen a lot of the celebrities now turn into this, I'm not giving any money to my kids because I want them to go through the same struggles, same as the chicken. The chickens died because they didn't go through what nature intended, which is the struggle to get it. You have money. You've made your money because you worked, you sacrificed, you gave up things in order to accumulate that money. It's an exchange of nature, right? When you just willy-nilly go, I got a trust, it's going to eliminate probate. Nah, just give them the money when I die. I don't want to deal with it. That's kind of it's worse than anything because it hurts people. And, well, we could talk about the asset protection that, the bloodline trust provides. But I can tell you the tears that I've shed just watching 18 and 19 and 20-year-old kids just blow themselves up because parents and grandparents haven't thought through what money given in the wrong method could actually do. Now, with that in mind, what I was intending to do today, and I just looked at it, is I was going to cover a lot of different things here. And it looks like we've only really gotten through what is a probate trust, bloodline trust, what kind of protection do you want to provide for the beneficiaries. And then also we got into, how do you want to create incentive clauses? So we've got a couple other missing areas. So what I'm going to do now is I'm going to go ahead and create an advanced trusts part 3. And in that part 3, what I'll do is we'll post it on our website, which is hhrdm.com/events. You can go to our webpage our YouTube page. Just Google H&H Retirement on YouTube, and I'll post it there, as well as our Facebook page. Because this is extensive, I'm probably already over an hour now. And so what I'm going to do is just break this up into another advanced trust part 3. Hey, great. Thank you for listening. Hopefully this is kind of giving you a little bit insight into the better ways to not just get a trust, but on how to design it and think through what you want. I'm going to sign off now.